28-2101B, the State of Texas versus Aurora Greenway. State ready to proceed?
Yes, Your Honor, with the state ready to proceed.
Defense ready to proceed?
Yes, Your Honor.
All right, let me remind counsel this is a stately old courtroom. It's very elegant, but it was built before the days of air conditioning. Therefore, the acoustics are not very good when the air conditioner's on. So I ask you to be sure to keep your voice up out loud so all counsel and the court reporters can hear you. All right, call your first witness, or do you wish to make another mistake?
Yes, Your Honor, may we proceed?
Yes.
Before we proceed, though, I'd like to ask the court if they had a chance to review the stipulated facts, and if not, we'd be glad to read them into evidence.
The court has, in fact, reviewed stipulated facts, and I'll be part of the record.
Thank you, Your Honor. May I begin?
Yes, ma'am.
May it please the court, opposing counsel, members of the jury. Y'all want to start here?
Address your remarks to the jury.
Okay, Okay. On June 13th of last year, a young lady by the name of M. Greenway lay in a hospital bed in a coma brought on by a reaction to cancer-controlling medication. In the early morning hours of June 14th, M. died, but not from the coma or from the cancer. Evidence will prove that she died because someone unplugged the life support system that was keeping her alive. My name is Russ McManus. Among my associates, Eric Ranger and Brandon Minton, we represent the state of Texas in this case that charges the defendant, or Greenway, with this offense. You have been called here today to hear the testimony, to hear the facts that will prove that the defendant is guilty of that murder. We must prove to you beyond a reasonable doubt that the defendant is guilty of these offenses. Today we have been charged to prove that, number one, the disconnection of the life support system led to M's untimely death. Number two, that Ms. Greenway disconnected the life support system. And number three, that she knowingly and intentionally ended her daughter's life. Today we'll be calling three witnesses to the stand. First we'll call Ms. Pat Clark to the stand. Ms. Clark will testify about Ms. Greenway's behavior while M was in the hospital. She will reveal the events on the night of M's death, like what was said and done by Aurora Greenway. The main thing we ask you to listen for concerns what Pat saw the defendant doing in those early morning hours of June 14th. Our next witness will be Dr. Jordan Ratchford. Dr. Ratchford is M's family physician, and you will learn from Dr. Ratchford that Aurora Greenway's moods were always unpredictable and subject to abrupt change. You will learn from Dr. Ratchford that on June 10th, 1998, M lapsed into a coma. Then she had to be placed on a life support system to sustain her life. Next, you'll learn at 3:40 a.m. on June 14th, M was pronounced dead. Finally, we ask you to listen to the evidence of Dr. Ratchford and how he explains the cause of death. And he will explain the cause of death to be interruption of the life support system. Our final witness will be Flap Horton. Mr. Horton is husband to the victim, M. Greenway. He will tell you of Ms. Greenway's mood swings at the hospital and how they affected the personnel at the hospital. He will continue to tell you his feelings about M. Greenway and her death. He will also explain how he believes she died. Listen to Mr. Horton about who was in the hospital that night and who was always in the hospital at night, which was Aurora Greenway. Even he was not allowed to be with his wife. You ask who wouldn't let him in the room? The doctors, the nurses? No, it was the defendant who would not allow her son-in-law to be with his wife. The defense will bring their witnesses to the stand. Mr. Garrett Breedlove, Ms. Rosie Dunlop, and Aurora Greenway. The defense will try to provide some sort of doubt that the defendant did not knowingly and intentionally terminate her daughter's life. And at some point in the trial, the defense may try to point the finger of guilt at Mr. Horton or Ms. Clark. But you must remember that the only person on trial here today is Aurora Greenway, the defendant. We thank you for coming here today, and we ask that you give this victim of an undeserved death the justice she is due. Thank you.
Defense wish to make no mistake.
Yes, Your Honor. May it please come. You'll soon hear that in the late night hours of June the 13th, 1998, a woman and a mother, namely Mrs. Aurora Greenway, tended to her daughter who lay suffering in a coma. As she finished caring for her daughter, she tucked her in. She said goodnight. However, on this particular night, she did not know that this would be her last chance ever to do that. For she awoke in the early morning hours of June the 14th, 1998, to hear the beeping of an alarm and the flashing lights. Something told her that something had gone wrong. Em had stopped breathing. She rushed frantically around the room, trying to do everything in her power to revive her daughter. But neither she, nor the nurses, nor the good Dr. Ratchford himself could ever bring him back. Ladies and gentlemen, my name is Randy Woodward, and I, along with my co-counsel Jonathan Stovall and Justin Rush, today represent a woman and a mother accused of murdering the one which she held most dear, her daughter, Em Greenway. That, folks, that is unreasonable. Now today we expect the prosecution will want you to see otherwise, and they're going to try and bring 3 witnesses up here on the stand today to tell you otherwise. These 3 witnesses would like to rip my client up one side and down the other. But ladies and gentlemen, you'll soon see from Dr. Jordan Ratchford, who you'll find doesn't know exactly what happened that night. You'll see Mrs. Clark, who doesn't know exactly what she saw that night. And finally, we expect they'll bring Flap Horton to the stand, who you'll hear from and find out that he was so concerned with life's little affairs that he wasn't even there. Now folks, all the witnesses today, they'll tell you she was a controller. She was a fighter. No one disputes that today. She was a fighter. She fought for what she believed in. And what she believed was her daughter was going to pull through that coma. Now folks, we have also brought 3 witnesses of our own today, including the defendant herself. And today they look forward to testifying to you. They look forward to showing you everything that they know about that night. We as a co-counsel look forward to guiding you through these testimonies, guiding you through this process, and showing you, the jury, the facts and the truth about Mrs. Aurora Greenway.
May I approach the bench?
Yes. That's fine. We're going to address a minor logistical problem. Appreciate your involvement. All right, call your first witness.
Your Honor, at this time, the state calls Pat Clark to the stand.
All right, Pat Clark, come forward, please. You raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth, so help me God? Now, you can see here, be sure to keep the microphone on these 2.
Good afternoon. Would you please state your name and age for the record?
Pat, I'm 28 years old,
And Pat, where do you currently reside?
in Federal City, Pittsburgh.
How do you know the defendant, Aurora Greenway?
Aurora Greenway is in Southern.
And could you please tell the court about your relationship with her daughter, Em Greenway?
Well, me and him share a very close friendship. We've been best friends ever since the 3rd grade, but as we got older, we kind of went our separate ways.
And how did Em's mother, Aurora Greenway, act towards you?
Well, she just acted like she never was right.
Do you have any idea why?
Well, it was obvious she was very controlling and protective over Em, and she was in the fact that Em would just share things with me that she couldn't even share with her.
Right now, I'd like to take you back to the time when Em first became ill. How did that affect your relationship with her?
Well, when she first became ill, she called me before that when her son began having marital problems, and when that had happened, a little later she was diagnosed with cancer, and we were able to friendship right after that.
And Pat, when Elm Greenway was admitted to Curie Memorial Medical Hospital, did you ever try to visit her during the normal visiting hours?
Yes, I did.
And how did that go?
It was usually unsuccessful. Aurora really rarely allowed me to see her best friend.
Pat, how were you able to see Elm while she was in the hospital?
I learned to time my visits in order to see my best friend, and I had to avoid Aurora, so it was necessary to time the visits.
And how did Aurora act whenever you did see your best friend?
Well, she was usually just very controlling, as usual, and she constantly said that I was a disruption and shouldn't be allowed to see him.
And Pat, to the best of your knowledge, were you ever disruptive in your visits with Elm Greenway?
Not at all, not in the least. If anything, Em and Aurora was the disruption, constantly saying that she should be the only one to see Em each night.
Alright, right now I'm going to take you back to on the night of June 13th and the early morning hours of June 14th, 1998. What were your plans for that evening?
Well, I intended on going to a party in Constantine.
And what, if anything, happened on your way to that party?
Well, first I passed out of the hospital and just decided that I would stop in and see my best friend.
And what happened whenever you went to go see your best friend?
Well, immediately I was confronted with Aurora.
And what, if anything, did the defendant, Aurora Greenway, say to you at that time?
Well, first she had saw me, she jumped up and pushed me out of the room like I'd done something wrong and said that I shouldn't be allowed to go into the room.
And do you have any idea why she said this?
No idea at all.
Well, what happened next, Pat?
Well, after she had said that, I proceeded to tell her that Em was just my best friend and she was in a coma and I'm like, being your best friend, I wanted to see her. Then she started to say that Em wasn't going to come out of the coma and she wasn't going to survive.
And what happened after that?
She had just jumped down my throat and said that this was a special night and that everything had to be just so.
And where did you go to next after that encounter?
Well, she pushed me up against the elevator and told me that maybe if I would get some peace now, that maybe she would get some peace, so I went to go to the party.
And what happened at the party that you went to?
I was quite distraught by the way Aurora had treated me because I wanted to see my best friend. I think that that would be the last time for me to see her. And that I drank quite a bit at the party.
And what did you drink?
I just drank quite a bit of alcohol.
Okay, and where did you go to after the party?
Well, after the band had played, I went back to see Ian again. I brought a peace offering for Aurora and a plate of leftovers from the party, knowing that she would gain a favor of that.
And what did you do whenever you arrived at the hospital?
Well, I stepped into the room and I saw her laying down beside the bed doing something with her plug.
And do you have any idea what plug this was?
I'm not sure which plug. I wasn't there to see her unplug it or anything, but I just saw her doing something with it.
And do you, okay. What did you do next? Or what happened next, Pat?
Well, she looked up at me and said that Em's care was none of my business and it would be fine.
What? Are you okay? What happened next, Pat?
I decided that I was in a mood for an argument. So I just left.
And what occurred after that, Pat?
Well, on my way home, I got confused by the police under suspicion of a DUI.
And what did the police officers do to you at that time?
Well, I insisted that they bring me to the police station for a blood test.
And what did this blood test show?
That I was not under the influence at all.
Okay. How do you feel about Em's children?
I love Em's children very much.
How does that affect your testimony here today?
Not in the least.
And Pat, what, if anything, did you learn about the cause of your best friend's death?
And they told me she'd suffered respiratory failure during the night due to something contaminated
the night that M died, what did you later learn about her condition?
She was not fine. M died that night. Aurora never allowed me to see my best friend.
Did you attend your best friend's funeral?
Yes, I did.
And was Flatporton, her husband, there?
Yes, he was.
And how did he act?
He just acted so distraught, like his whole world had fallen apart.
And was the defendant, Aurora Greenway, at that funeral too?
She was also there.
And how did she act?
She acted relieved, like she didn't even care, like a cat that ate the canary.
And what do you mean by that statement? She acted like the cat that ate the canary.
I thought she had something to hide, something she had done.
At this time, we pass the witness, Your Honor.
All right, Cross.
Yes, sir. Well, Mrs. Clark, my name is Randy Luther. I'll be asking you a few questions today. Now, Mrs. Clark, you're best friends with Ben Greenway, is that correct? You've been best friends for quite some time? And ever since early on in this relationship, you were always considered to be a bad influence, is that correct? Now, Mrs. Clark, let's move closer to the time of M's diagnosis. Before M's diagnosis, you and M had not seen each other in quite some time.
Well, she called me earlier on.
But had you remained in fairly decent contact throughout the years?
With a few phone calls, yes.
But after M's diagnosis, your relationship recently rekindled in that you saw each other.
That's correct. She called me and heard about me having their other problems before the diagnosis.
Did you proceed to go to Petro City and visit with her?
Yes, after the diagnosis of cancer, I did.
And on several occasions, you took care of M's 3 children, is that correct? While she was sick? Should the opportunity arise, would you be willing to take custody of the children?
Objection, Your Honor. I fail to see the relevance of this question.
Relevant.
Your Honor, it's relevant in the fact that it goes to present bias on behalf of the witness.
It's done. I mean, overruled. See.
Do you need me to repeat the question? Should opportunity arise, you would be willing to take custody of those children, is that correct?
Yes, I would. I love M's children as well.
You care for those children.
Yes, I do.
Now, do you have any children of your own, Mrs. Clark?
No, sadly, I'm an infection.
You are aware today, Mrs. Clark, that should Aurora Greenway be convicted, that you will be gaining custody of Melanie and possibly the 2 boys, is that correct?
Yes, me and Flavia made arrangements, and if he does not want them, I'll be glad to take them.
Now, I would like to talk to you about the events surrounding the night of M's death, and through a series of questions, I'm going to take you through that. Are you ready? Now, on June 13th, you first arrived at the hospital between the hours of 8 and 9 p.m., is that correct? And from that particular visit, you were asked to leave your room, and you proceeded to go to a party after this. And at this party, you were upset from the previous nights and incidents.
Yes, sir.
So to relax at night, you had some alcohol, Mrs. Clark.
Yes, I was.
Now, do you remember exactly how many drinks you had that night, Mrs. Clark?
Objection, Your Honor. I fail to see the relevance of this question, in this line of questioning.
She stated earlier she wasn't intoxicated at any point during the night, and I'm just going to prove that she was. And considering the fact that she's here to testify as an eyewitness to the events at hand, it's imperative that the jury know if she had any ulterior
May I
substance.
respond, Your Honor?
You may.
In the mock trials rules of evidence, rule number 601 says that a witness's character is not on trial, and Ms. Clark is not the defendant in this case, and her character is not on trial here. Neither is her reputation. The only thing that should be considered is her truthfulness.
May I respond, Your Honor?
I don't think you need to. I think the testimony goes to, line of testimony goes to the witness's power of observation, ability to observe and remember and testify, not his character. Therefore, I'm not overruled.
Now, Mrs. Clark, do you remember exactly how many drinks you had that night?
No, not exactly. I just know I had a bottle.
So you did have a lot to drink that night?
Yes.
So, after partying and all this drinking, you drove back to the hospital for a second visit?
Yes, I drove back to the hospital.
Did you see that?
Yes.
And this was around 2 o'clock in the morning. But before seeing him, you fell asleep in your car, is that correct?
Yes, it was.
Objection, I don't see the relevance of that question.
Your Honor, it's just going further to show that she said she wasn't intoxicated, and I don't see that this is a usual behavior for someone who's in their right state.
May I respond to that?
Go ahead.
Your Honor, they are trying to speculate that my witness was intoxicated, when in fact a blood test did show that she was not intoxicated at any time on the night of on June 13th and the early morning hours of June 14th.
I understand your position, counsel. However, the fact that the witness may not have been legally intoxicated does not diminish the ability for the evidence as to her powers of observation. Therefore, I'm going to overrule.
Thank you, Your Honor. Any other questions? Now, is it true that you fell asleep in your car that night?
That's true. I was just, it was late at night. I was pretty tired, so I need to put it down.
So is it a personal habit of yours to fall asleep in your car, Mrs. Clark?
No.
So you would agree with me in saying that this was restricted to just that night?
Objection, relevance, Your Honor.
Your Honor, I'm still just trying to establish my point.
Well, I think you're in an area of relevance. However, I think you're reaching a point where we may want to go on to another point, but I will overrule the objection if you wish to proceed along this line.
I'll sum it up, Your Honor. So the night you were sleeping in the car, this was the night you were drinking, correct? Now, from the hospital, you finally went to go home. And at this time, you were pulled over for suspicion of driving under the influence.
That's correct.
This was between 3 and 3:40 in the morning. Now, earlier when you were being directed, you stated that at no point in the night were you under the influence at all. Is that correct? However, after refusing to take the breathalyzer, you were taken for a blood alcohol test. Is that correct? And at this point, you were only 1 point under the legal limit. And this was approximately 2 hours or more after your last drink. Is that correct?
This would have been 2 hours or less because between 2 and 3:40, that's not even 2 hours. So it was probably an hour and a half.
So an hour and a half, you were still only 1 point under the legal limit.
That's correct.
That's the witness.
Yes, Your Honor, may I proceed? Pat, once again, what did the blood test that the police officers gave you show?
Yeah, I was not drunk.
And at this time, we have no further questions.
Short cross, Your Honor.
All right.
Mrs. Clark, you stated earlier in your tax statement that some parts of that night are fuzzy. Is that correct?
Few points, yes.
I have one further question for you. Did you ever see Mrs. Gray pull the blood test?
Objection, Your Honor, this is beyond the scope of my redirect.
I need a point of order for the mock trial. It's my understanding the rules of the mock trial don't limit the, you're not limited to the last round of questioning. If that's not true, that's a statement objection. But it's my understanding that I read the rules that there was no limitation on direct and redirect to the scope of the prior rounds.
I believe, Your Honor, that his recross questions can only be about my redirect.
That's true under the Texas Rules of Evidence and Procedure, but I
It is
thought
true
I
under
read
the
that,
I found the rule, Your Honor, if you'd like me to read it at this time.
what is it?
I believe it's Rule 202, Scope of Witness Examination.
All right,
Page number 15.
right, I'm with you.
Okay. Scope of witness examination. In mock trial competition, attorneys are allowed unlimited range on cross-examination of witnesses as long as questions are relevant to the case. Witnesses must be called by their own team and may not be recalled by either side. Therefore, all desired questioning of a particular witness may be done by both sides in a single appearance on the witness stand.
Your Honor, I have another ruling. That was on cross, that rule that he read from. This is on the recross, and the rule, I believe, is 401. It says, additional questions may be asked by the cross-examining attorney, but they are usually limited to the matters raised by the redirect and should avoid repetition.
All right, objection sustained.
Your Honor.
Now, Mrs. Clark,
Your Honor, I also ask that be stricken from the record, that last question.
All right, question is clear.
Mrs. Clark, you did state that parts of that night were fuzzy, is that correct?
Yes, of course.
Ask the witness.
Dean Merle?
No, Your Honor, at this time we ask that Pat Clark be dismissed from the stand.
All right, you can stay. Right, next witness.
Yes, Your Honor, at this time we would like to call Dr. Jordan Rashford to the stand.
Ms. Rashford, will come forward. You solemnly swear or affirm that testimony she'll give us now be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you. Have a seat. Be sure to speak in the microphone.
May I proceed? Thank you. Dr. Rashford, could you please state your full name and where you currently live for the record?
My name is Dr. Brooke Westbrook, and I live in Vidor.
And what do you currently do for a living?
I am a physician.
And where did you go to school to get your medical degree?
I went to the University of Texas Oklahoma for 4 years to receive my medical degree, which I then received by 4 years at basic college, followed by 4 years residency at Crew Memorial Hospital, followed by 1 year fellowship.
And as a doctor, what fields of medicine do you specialize in?
Family practice. I
And
deal with day-to-day problems like sprains, infections, bruises, and stuff like that.
thank you. Do you have a wide range of medical knowledge?
Yes, I have very wide.
And how long have you been practicing Petro?
22 years.
And aside from Petro, have you practiced anywhere else?
Yes, 2 weeks out of every summer, I travel to New Mexico where I do work for the court.
And over these years, how many patients would you say you had?
Over the years, I'd say thousands.
And among these thousands, have any of them had cancer?
Yes, I have.
Did you treat any of these patients directly?
No, I never treat cancer patients directly. I always refer them to specialists.
And is it common practice to refer patients like this to specialists?
Yes, it is.
One more question. Did you ever deal with the specific type of cancer in Greenway Act?
McMurphy syndrome, which you suffer from, yes, I did do it.
Your Honor, at this time, we would like the record to reflect that Dr. Rashford is an expert in the medical field.
Your Honor, that's not a problem. I would just like to point out that in the state of Texoma, the situation of expert witnesses is not recognized. It is something for the jury to determine.
All right, well, I presume that the request is predicate to asking a certain amount of questions of this witness.
Yes, sir. Just simply that the jury would be acknowledged, would be instructed to hold the witness's testimony in regard to that certain stipulation that expert witnesses are at the jury's discretion.
All right. You can proceed.
Thank you. Doctor, can you please tell us what happened on June 10th, 1998?
On June 10th, in Greenway, that's in Oklahoma, due to adverse reactions to cancer control medication.
And based on your medical knowledge, do patients in comas feel pain?
Recent studies that are inconclusive.
Aside from being, if I'm going to move on, aside from being the attending physician to the Greenway family, have you had a personal relationship to them?
Yes, yes, I have. I'm a family friend.
And how long have you had this relationship?
For many years, since Embassy Austin.
And in these years that you've known the Greenway family and Aurora Greenway, what did you observe about her character?
My first-hand observations were that she's very passionate woman. She can be a bit temperamental at times.
And have you ever, do you have any personal accounts?
Yes, 1 year at a birthday party in the Greenway home, Aurora's birthday specifically.
Objection, Your Honor. The witness is launching to a narrative.
Your Honor, if you allow me to, I'll break up the line of questioning about the city.
All right, you phrase your question.
Do you recall what happened 1 year at one of Aurora's birthdays?
I revealed her true age and was thrown out of her home.
Do you recall what happened on June 14th, 1998?
I was on call at Crew Memorial Hospital, and I was called in to wait.
And what happened, what did you observe when you realized, when you walked into the room?
I I observed that the doctors and nurses had just finished attempting unsuccessfully to resuscitate Miss Greenway.
And what were you told to do after that?
I then filled out the death certificate and announced the deceased.
Your Honor, may I approach?
Yes, ma'am.
As Marcus says, this is a good one.
Yes, ma'am.
Dr. Rafferty, could you please identify yourself?
This is Miss Greenway's certificate of death.
And can you verify it's authenticity?
It is the authentic document.
Is this your signature?
This is.
Thank you. I would now like to remind the court that the authenticity of this document has been stipulated, and I now tender it to a closing statement.
Yes, Your Honor, we object on the grounds that this is hearsay.
Your Honor, this is a regularly kept business record of the hospital.
I'll respond. Your Honor, this has not been established as a business record. Common predicate has not been laid.
Not legal predicate, and are the only admissible exceptions to hearsay set forth in the rules.
Yes, Your Honor.
And your objection is sustained.
Dr. Radford, based on your recollection of the situation, do you recall what was the time of death of M. Greenway?
I pronounced Miss Greenway dead at 3:40.
And according to your recollection, what was the cause of her death?
It was respiratory failure.
And what caused this respiratory failure?
Interruption of the life support system.
Is it possible that this interruption was a malfunction of the life support system?
No, it's not.
And why is that?
It was apparent that someone had tampered with the life support system.
All right. And how do you know it had been tampered with?
A lot of people,
Do you know what time the respirator stopped functioning?
the respirator stopped functioning at 3:08.
Now, do you know if this is the time that M. Greenway died?
No, that's not the time we were moving away from the announced at 3:40.
Do you know if this is the exact time when the machine was unplugged?
No, because you have to take into account the fail-safe mechanism for battery backup.
Nevertheless, whether or not the machine had a fail-safe mechanism, would M have eventually stopped breathing that night?
Yes, you have.
Would she have died because of that?
Objection, Your Honor, this is speculation. Whether or not she would have died because of this, the opposite, they attempted to resuscitate her, so that must be taken into account here. This is speculation.
Question to the witnesses, had the, re-ask your question, if you would please, counsel.
Your Honor, the question was whether the witness would have died due to her not having the ability to breathe.
In other words, you're asking this witness to give an opinion as to whether the disconnection of the respirator was the cause of death?
Yes, sir.
All right, call the roll.
Would you have a question?
Yes, Your Honor. I'm sorry. Yes, Dr. Radford. Was the disconnection of the life support system, how did this affect him?
The disconnection of the life support system stopped, did not necessarily mean that it stopped breathing right away, because being in 4 days of the coma, we don't know if she could breathe on her own for a time, but she was pronounced dead at 3:40. The human brain can only live without oxygen for 6 minutes, so she must have stopped breathing at 3:40.
If I may move on. Do you believe in mercy killing?
No, I'm strongly opposed to euthanasia.
And what are your thoughts on, do you have trouble believing that Aurora Greenway committed this crime?
Yes, it's hard to believe. Most of it is.
Your Honor, at this time we pass the witness.
Dr. Radford, you received your medical degree from the University of Texas, Oklahoma. Is that correct?
That is correct.
And this took a lot of work, didn't it, Dr. Radford?
Yes, it is.
Now, you practice as a family practitioner, is that correct?
Yes,
And you would consider yourself a good doctor?
of course.
And you know that Aurora Greenway is being accused of pulling said life support system that you referred to, is that correct?
I'm aware of that.
And this life support system is pretty complicated, isn't it, Dr. Radford?
I would imagine so.
They don't just put these things, like, say, outside, like in the playground for the children to play with, do they?
Objection, Your Honor. I fail to see the relevancy of this question.
Kind of show that it would take an experienced technician to stop one of these things from operating. You can't just yank them out of order.
All right, if the witness can answer that question, you can answer it, otherwise you can be afraid to get to the point where you
Yes.
overrule.
Once again, Dr. Ashford, you have never seen a life support system in the nursery, have you, Dr. Ashford?
In the nursery,
Or in the playground outside?
in the nursery, you prove your baby's alive, they're in the last. In the playground, however, no, I don't think medical equipment's present.
Now, Aurora Greenway was not an experienced technician to your personal knowledge, was she?
No, she was not.
Now, going back before the incident, M. Greenway came back to Nebraska seeking medical attention from you, correct? And she had been diagnosed with McMurtry syndrome, is that correct?
That is correct.
And now, oncology or cancer treatment is not your specialty, is it, Dr. Ashford?
No, so I referred her to Dr. McCrae.
Right, and you do that because you have your own personal policy of referring patients when necessary, correct?
Of course.
And you would have considered it malpractice to treat the symptom.
Yes.
However, when M slipped into a coma, Dr. Ashford, you didn't refer her to a neurologist or a coma specialist, did you?
I think you're asking the wrong doctor. Her coma was brought on by medication prescribed by Dr. McCrae. It was his responsibility to refer her, not mine.
Dr. Ashford, you didn't see to it that she was referred to a neurologist, did you, Dr. Ashford?
It was Dr. McCrae's job, not mine.
Dr. Ashford, once again, you're not a specialist in neurology, are you? Or coma dealings, are you, Dr. Ashford? And you would consider it malpractice to attempt to treat a symptom in which you had no formal training, correct?
Yes, I did not do the coma.
Dr. Ashford, isn't it true that you're being sued right now for negligence, along with the hospital?
Your Honor, I fail to see the relevance of whether my client is being.
Yeah, this is relevant because it shows that Dr. Ashford has a bias to testify against my client, and that if she can blame somebody else for this death, she is obviously not negligent in this case, in this lawsuit that she's being sued right now.
Overrule.
So, Dr. Ashford, you're being sued right now for negligence in your dealings with M. Greenway, is that correct?
Then when a patient dies.
Dr. Ashford, you're not responsive, Your Honor.
Sustained, doctor, answer the question.
Dr. Ashford, you're being sued right now for negligence, correct? And so somebody must have thought, somebody thinks that you could have perhaps prevented, you and the hospital combined, could have helped prevent the death of M. Greenway, is that correct? And Dr. Ashford, isn't it true that Flat Horton is the plaintiff in this lawsuit?
I believe Flat Horton was the one that.
Now, Dr. Ashford, to your personal knowledge, has anyone seen unplugging that respirator?
To my personal knowledge, no.
Dr. Ashford, you don't know exactly when that respirator was unplugged either, do you?
No.
And Dr. Ashford, you don't know exactly when M stopped breathing.
She stopped breathing 3 or 4.
Do you remember making a fact statement this morning, Dr. Ashford?
Yes.
You signed this fact statement, right?
A fact said this morning, I made it to dinner.
This morning you didn't, right?
Yes.
And in this addendum, you stated that at this point it was not certain when M's breathing stopped completely. Is that correct?
It is certain now. You can only survive with oxygen for 6 minutes.
At this point this morning, you said this morning, right? At
Yes,
this point?
before the trial started, it was.
Right. Now, Dr. Ashford, you're also not exactly certain exactly when the alarm was triggered either, are you?
I was never in the room, no.
So, Dr. Ashford, once again, you didn't see anybody, much less Aurora Greenway, pull that plug, did you? That's what it's shot.
Please, Your Honor.
Yes, Your Honor. Are you certain whether or not he would have died that night if she would have not had the life support system operating?
If she would have not had the life support system operating, can you repeat your question?
Would it have died that night if the life support system was operating?
No, she did not have it.
Was the point of M's cancer terminal? And once again, what was the cause of M's death?
Respiratory failure with an intentional interruption of life support.
And how do you know this interruption was intentional?
Like a tool.
All right, this time we have no further questions.
Couple of questions for Ross.
All right. Let me see.
Oh, just, no, a couple of questions.
Oh, I think you said no
Sure.
more. I'm sorry, Counsel.
Just one or two.
All right.
Now, Dr. Ratchet, isn't it true that you stated that the cause of death is interruption of life support system due to, respiratory failure due to interruption of the life support system, is that correct? And the words intentionally were never in that statement, were they? Second time. That's not what you testified to earlier, is it? No further questions.
Yes, sir.
All right.
Despite whether or not,
Your Honor, you only get one redirect shown.
Oh, is that right?
Yes, sir.
Is that correct?
Yes,
All right.
yes, sir.
Then I sustain the objection.
Your Honor, this time may those witnesses said.
Yes, you may.
At this time, may we call Flap Horton to the stand?
All right. Work. You do solemnly swear or affirm testimony you shall give in this matter will be true, the whole truth, and nothing but the truth, so help you God. Now, if you have a seat before, be sure to speak in the microphone when you do speak.
Good morning, Mr. Horton. Would you please state your name and age for the court?
My name is Scott Horton, and I'm 36 years old.
What is your occupation?
I'm currently a teacher at Vidor City Community College.
What position do you hold at that college?
I hold the valedictorian bachelor in literature.
What do you teach at this college?
I teach a graduate course in contemporary romance novels and English 101.
Who is M. Greenway?
She was my wife.
And what is your relationship to the defendant, Laura Greenway?
Laura Greenway is my ex-mother-in-law.
And what impression do you get of Miss Greenway's attitude toward you?
It's an impression of very really careful.
Would you please give the jury an example of why you feel this way?
Whenever him and I got married, Laura usually was in the life.
How many kids do you have?
I have 3. I'm taking one.
And when your first son was born, what happened to your marriage?
It began to deteriorate.
What was the defendant's reaction to your first son being born?
Laura completely looked her lid. She said that looking at her granddaughters, they should put her in a grave.
Where do you currently live, Mr. Horton? And what happened while you were in Petro City?
And began to take her to the
When M became ill, why did you take the job at Petro Community College?
So I could go to the urinary illness and go to the
At the time of M's illness, what was the stage of your marriage?
We're still together, probably.
What effect did M's illness have on you?
It was really painful for me watching him go over any issues with me.
And what happened to M during the first round of chemotherapy?
He suffered from severe nausea, weight loss, depression, and was
Mr. Gordon, what were your hospital visitations like before M lapsed into a coma?
quite frequent. I would go to visit her and have conversations on either.
Who, if anyone, was there while you talked?
Or we're very constant.
And if any time, did you and your wife have time alone?
Or was always
What happened to M during her second round of chemotherapy?
halfway through she lapsed into a coma.
And what did you learn from the doctors about M recovery?
That she was most likely to come up with there was no hope about her cancer.
To the best of your knowledge, who was always in the hospital room at night with M?
Lord, help us.
Why do you say she was always in the room?
She insisted on staying there. She didn't have anyone else to do.
Who do you believe pulled the plug on the life support system that was keeping your wife alive? It's actually not speculation. Your Honor, my client is not speculation. This is what his belief is, and he is not saying that something actually happened.
Your Honor, I believe that his beliefs are relevant in this case. It's speculation.
Sustain.
Your Honor. Mr. Mr. Horton, who has custody of your children?
This is what we're doing.
And why does she have custody?
And this is what we want.
Does this bother you?
This is less good.
Why?
Because I don't think that Lori's going to, she's not on.
What did she do?
Just
Check
how
your
we pass
honor.
the witness, Your Honor.
Pardon? I'm sorry.
Objection,
You
Your
have two
Honor.
people talking at once. You have an objection to speculation.
Your Honor, we felt that this is speculation because this is justice belief.
Your Honor, this was already sustained as speculation.
Second roll is sustained.
Okay, may we pass the witness, Your Honor?
Your Honor, I'd like to ask that statement and the question be stricken from the record.
All right, last question, statement is stricken from the record. Yes, you may cast it.
Thank you, Your Honor.
And proceed, Your Honor.
Thank you.
Hello, Mr. Horton. My name is Justin Rush. First off, I'd just like to ask you a few questions about yourself. Are you currently married?
No.
You are married to M. Greenway, correct?
Yes, I was.
And you loved him?
Yes.
You were married to M for 10 years?
Yes.
You and M had 3 children, Tommy, Teddy, and Melanie.
Yes, I did.
And you love these children?
Yes. Very much.
Now, I'd like to talk to you for a moment about a relationship you had with a student. in
Objection, Your Honor.
classes.
May we approach? Here.
Mr. Horton, while you were working in Nebraska as a professor at the University of
Objection, Your Honor. We see the relevancy of about him working in Nebraska in this case of M. Greenway's death.
You'll have to allow him to finish his question before you object. I can't make a ruling until I hear the text of the question, so I'll allow him to ask the question.
While you were in Nebraska working, M was diagnosed with cancer, correct?
Yes, that's correct.
And when M went back to Petro City to be treated, you stayed behind in Nebraska to finish the semester.
Yes, but I left in the semester.
Now, Mr. Horton, you moved to Petro City from Nebraska when you were fired at
Objection, Your Honor. We see the we do not see the relevancy of him being fired in Petro City.
All right, I'll hear the relevance again. I'll talk to you. You need to allow him to finish his question before you object.
Thank you, Your Honor.
Go ahead.
Your Honor,
Relevancy?
yes, Your Honor. This is relevant because we're going to impeach the testimony he's already given that he moved to be with his wife.
May we approach, Your Honor, before he begins his statement?
Sure. spot, spot on the committee, that you move to the spot. John, I said, you have to check this. So, well, the reason for his termination may not be particularly relevant, but the fact that he was terminated, which will explain the reason for moving as opposed to, he's the section C, would be relevant. So I'm why he didn't that he was terminated for the next time he moved, and I'm talking not to be the reason for termination. Okay.
You moved to Petro City from Nebraska when you were fired at the University of Nebraska, correct?
Yes.
And without mentioning why you were fired because you violated a school policy, correct?
Yes, that's correct.
And this was a very serious violation of school policy, wasn't it?
The objection, I don't see the relevancy of the reason why he was being fired according to the hearing. Yeah.
I'm out of road.
The reason you were fired from Nebraska was because of a very serious violation of school policy, wasn't it?
Yes, the school board hearing process.
But you believe, you knew that this was against school policy, didn't you?
I believe so, yes.
But you thought you could keep this violation secret, didn't you?
Yeah.
Once your wife began to receive treatment for cancer, she spent most of her time at the hospital, didn't she?
Yes, she did.
Am's mother, Aurora Greenway, also spent all of her time at the hospital with her daughter.
4 hours.
So she knew exactly when each treatment procedure was supposed
Objection,
to
I recall speculation on my client to speculate how the defendant knew when each treatment was.
Your clients, state of Texas, you're talking about the witness?
I'm sorry, the witness.
Your Honor, I'm only asking the witness to tell what he knows about what happened.
All right, please raise your hand.
Thank you, Your Honor. Can we have a little?
I'm going to sustain the objection, but allow, I think the area of inquiry, the relevant area of inquiry, however, the format of the question is the objection, but I'll sustain the objection. All right,
Thank you, Your Honor.
please raise.
Mr. Horton, based on what you saw in the hospital, Aurora knew when procedures were supposed to take place in the hospital room.
Objection, it still calls for speculation.
The question asked is based on his perception. I'm allowing him to
Yes, I suppose so.
And Aurora made sure the treatments were given on schedule, didn't you?
Yes.
You went to visit your wife at the hospital sometimes, didn't you?
Yes. I wouldn't.
Did you visit every day?
Not every day, she wouldn't.
Did you bring your children to visit?
I might have to twice, not definitely wrong.
You didn't visit him sometimes because Aurora was at the hospital. Isn't that true?
And it's where it was quite pushy about things, so I didn't play dealing with her at times.
And you described your relationship with Aurora as strained tolerance.
She never got into more than all that.
So you're saying to the jury today that your mother-in-law is the reason you didn't visit your wife who had cancer.
I think I stated at school, but yes, I was close to the doors and
And Mr. Horton, after M passed away, you agreed to give Aurora custody of your 3 children, didn't you?
reluctantly, yes.
Now, M had a $250,000 life insurance policy.
Objection, Your Honor, we fail to see the relevancy of a life insurance policy according to the unpleasant of a life support proceeding.
All right, well,
Your Honor, again, we're just attempting to show bias on the witness's testimony as to why he would testify against the defendant, because it is because of the situation surrounding this, the witness has received a large sum of money, and therefore would probably, and therefore would definitely like to make sure that the situation is, would like that the defendant is found guilty so that no other circumstances are found strange.
you're trying to establish that the tendency of the existence of life insurance policy would give this witness motivation to implicate someone else?
Yes, Your Honor.
All right, overruled.
Mr. Horton, M had a life insurance policy worth $250,000.
This is already being signed on with me.
Aurora was there when it was signed.
Yes, close sign.
Now, when M died, the policy paid a total of $500,000.
Yes, that's correct. It was done with the digit.
Your Honor, may I approach the bench for the purpose of marking evidence?
Sure.
I'd like to have this marked as Defense Exhibit 1.
Well, you got it. I got it on your plan.
Oh, well, we got some.
Oh, okay. Oh, okay. All right.
May I approach the witness, Your Honor?
Yes, you may.
Do you recognize? Okay. Do you recognize this document?
Yes.
Would you agree with me that the name at the top of this document is Greenway and Bible?
Objection, Your Honor, we please ask the counsel not to ask what's on the document until he enters into evidence.
All right, stand. No, lay your credit before you go into content.
Thank you, Your Honor.
Mr. Short, would you agree with me that this is a deposit ticket indicating that some money was deposited into the account? And this is your account, correct?
Yes, I do see.
I'd like to remind the court that the authenticity of this document has been stipulated. I'm now turning it to the opposing counsel for any objections.
Your Honor, we feel this document is hearsay that was made out of court, and the publisher of this document is not here in court today to testify to whether it's truthful or not.
Purpose of the offer?
Your Honor, we're not offering it to prove the truth of the matter, sir. We're just offering it for what it is, and the witness has already verified that it is a bank deposit of his own.
But if there's no relevance other than the matters contained therein, which would be the truth, then it has no relevance. Then you have to advise me of something other than the matters contained in the document for it to be otherwise admissible. All right, I'll sustain the objection.
Thank you, Your Honor.
Mr. Horton, you received, when the life insurance policy paid the money, you received $500,000.
Objection, Your Honor, we just have this document is not in evidence, and we ask that counsel move on.
The question is whether you received it, so I'm going to overrule.
You did receive the $500,000 from the life insurance policy, didn't you?
Yes, and we're not listed in the trust fund.
But was it deposited into a personal account of your own?
Yes, and they're transferred to the trust fund.
Have the children received any of this money?
Not that they're receiving. Only their board of
The $500,000 were deposited into your account.
and then transferred to the trust fund. It's the state.
And Mr. Horton, you haven't seen your children much since M died, have you?
I've been teaching, and we're taking away from our group.
Mr. Horton, you can't bring yourself to look at your children, can you? You have difficulty.
Objection, Your Honor, we fail to see the relevancy of this line of questioning.
Relevant?
Your Honor, this is relevant because it goes to impeach his testimony to him caring for his children, that he admits himself that he cannot bring himself to look at his children.
And what's the relevance of that to the overall issue of this matter, which is the guilt or innocence of your client?
Well, Your Honor, I believe they've already asked the witness about his relationship with his children. Relevant.
Your Honor, we asked nothing about, we just asked if they had children.
Well, at this time, I'm sustaining the objection. I don't know the relevance at this point. If you want to try and establish relevance, all right, agree with it. However, I haven't heard any basis for the line of questioning.
Your Honor, we have already asked him if he cared for his children. He says that he does, and we were simply offering this to impeach that testimony that he doesn't care for his children enough to even look at them, much less be with them.
May I respond? Sure. That still isn't relevant to this case.
I don't see the relevance of this point. So I'm sustaining the objection.
Thank you, Your Honor.
All right.
Mr. Horton, you were not at the hospital on the night and died, were you? You were not at the hospital at any time during that day either, were you? Horton, you didn't see Aurora Greenway pull the plug on the life support system, did you?
Well, I don't believe she did.
Objection, Your Honor, speculation.
Sustained.
I'd like to ask that comment be stricken from the record.
Well, I'm going to ask the witness to answer the question, and then you can strike the comment. Witness is instructed to answer the question.
Thanks. Now,
And the question was,
the question was, did you see Aurora pull the plug?
No, I didn't see her.
Your Honor, you pass it.
okay.
May I proceed with my redirect?
Yes, you may.
Mr. Horton, why didn't you visit him in the hospital?
I think I stated, she would have to be busy, and plus we're really pushing out of there. Go see her.
It's time to pass it.
All right.
Your Honor, I have no comments.
All right, let me accept it.
Thank you.
And at this time, Your Honor, the state raised.
All right. Demonstrated calls for a witness.
Your Honor, we'd like to call Rosie Donovan.
All right. Call for this. You raise your right hand. Swear or affirm testimony to the witness now to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. If you have a seat, be sure to speak the microphone when you speak.
Morning, Ms. Donovan. Would you please turn and introduce yourself to the jury?
My name is Rosie Dunn, and I'm 57 years old.
Where do you currently live?
I currently live in Petro City, where I live for Shreveport business.
And do you enjoy your life here in Petro City?
Well, of course I do. I'm married, and I have 7 wonderful children.
Now, what do you do for a living here in Petro City?
I'm a domestic associate for the Greenwood family.
Now, to inform the jury what exactly a domestic associate does.
A domestic associate cooks and cleans and does other things that the family life would need to do.
And whose domestic associate are you?
Your Honor, could we please ask that the witness speak more into the mic?
Okay.
Not a speaker change there.
I don't, it's not my courtroom. I don't know if that's working or what.
Perhaps they should all just speak up a little bit.
Thank you.
Yeah, once again, Ms. Dunlop, whose domestic associate are you?
I am the domestic associate for the Greenway family
And how long have you been their domestic associate?
since 1970, so right around 28 to 29 years.
And throughout these years, have you been able to work closely with this family?
Yes, I believe about that.
Had you come to know M pretty good throughout the course of this time?
Yes, I believe I have.
Do you know why you're in court today?
Yes, I do.
Inform the jury why you feel you're in court today.
I feel I'm in court today to knock some sense into all the people who think that Aurora did this crime.
Now, were you and Aurora friends?
Yes, sir.
And throughout these years, have you been able to observe Aurora's personality and her temperament?
Yes, I think I have.
And what types of things have you observed?
I have observed Aurora to be very passionate, to be a fighter, with everything.
Did you observe her throughout the course of M's illness?
Yes, sir, I did.
And did she continue to appear to be, like you said, passionate and loving?
Yes, sir.
Why do you think that? What kind of things did she do that made you think that?
Well,
In other words, what specific examples can you recall that made you think that she really continued to be passionate and loving throughout M's illness?
well, I think she was passionate and loving because she became very interested in the pain topic for patients, and she started to try and learn everything she could dealing with pain and things like that.
Now you mentioned the pain here. specifically, if anything, what did you notice anything on a close basis with Aurora that made you really focus and think that she was really focused on pain?
Yes, sir. I saw her, well, I started seeing articles and clippings on newspapers, things like that, laying around the house that would deal with pain and things like that for patients.
How did she, based on your observations, how did she react to these type of articles and clippings, as you say?
Well, it really upset her because she knew that there was nothing she could do to stop the pain that her daughter was feeling. That really upset her.
Did you continue to observe Aurora's behavior while M was in the hospital?
Yes, sir.
What type of care did you observe Aurora giving M?
I observed Aurora giving me the best possible care she could.
Solely in your opinion, again, Ms. Dunlop, did everything she do appear to increase M's quality of life?
Yes, sir.
Objection, Your Honor, this question calls for speculation.
I'm sorry,
This question calls for speculation.
repeat your question.
Based on your observations, did everything she do appear to increase the quality of life of M Greenway?
Your Honor, I believe opposing counsel said based on your opinion.
All right, as rephrased out loud.
Okay. Rosie, based on your observations,
Your Honor, could we ask for a ruling on that matter?
Well, if I'm going to allow the witness to give an opinion of whether it improves the quality based on her perception. If it calls for her speculating, I understand, but as I understand the question, that's ordered to ask her to testify on her perception, therefore I'm not going to.
Ms. Dunlop, once again, based on your observations, did everything Aurora do appear to increase M's quality of life?
Yes.
Now, did she ever mention anything to you, even hint at anything that would cause you to think that she wanted to give up this fight?
Objection, Your Honor, this question calls for hearsay.
Your Honor.
The question is whether the defendant ever did anything, or
If she ever heard anything or did anything specifically that would make her think that.
and that's the defendant.
Right.
Overruled.
Commission up. And once again, Ms. Dunlop, did Aurora Greenwood ever say or do anything to make you think that she wanted to give up this fight?
No, sir.
And now, based on your observations, Ms. Dunlop, could Aurora Greenway have murdered her own daughter?
No.
Pass the witness.
Yes, Your Honor. You've been the domestic associate for the Greenway family for years,
Yes, sir.
and you have been the domestic associate for so many years that you're now getting paid double.
Objection, Your Honor. Have you approached the bench?
This is improper impeaching witnesses. The fact that she gets paid, but they're trying to simplify it. The fact that she gets paid establishes a violation of which to cause. Whether she's paid 2 times or not, or going less than 10 times is not an issue.
I'm going to give you a ruling. Overruled.
Do you need me to repeat the question?
Yes, sir.
You've been the domestic associate of the Greenway family so long that you're now being paid double.
Yes, sir.
And your job status with the Greenways caused you to be somewhat uncooperative with the police during questioning of this case?
Objection, Your Honor. This is irrelevant. This is seeking, again, to improperly impeach my witness.
Overruled.
Your job status with the Greenway family concerning getting paid such a large amount caused you to be somewhat uncooperative with the police during the questioning of this case?
That is what I said in my,
Fact set.
yes.
Thank you. During exam and illness, Ms. Greenway became very interested in pain, is that correct?
Yes, sir.
Would this include possible ways to alleviate that pain?
It could possibly.
Aurora helped M through her problems, is that correct?
Yes, she did try to help him whenever she possibly could.
be the monetary, marital, etc.?
Yes, I believe so.
In your statement, you also say that M was a fighter,
Yes, sir.
that she would never back down from a fight.
Yes, I believe so.
Also in your statement, you say that one time the city council tried to put a crosswalk at the end of your road, and that Ms. Greenway put an end to it.
Yes, I believe so.
Was this one of the fights that you didn't back down from?
Yes, sir.
Would that be because this crosswalk was somewhat of an inconvenience to her?
Objection, Your Honor, this is speculation. Whether, why Aurora did this, just that she did. And that statement was stricken from the record.
All right, statement is clear.
Ms. Dunlop, in your statement, you say that M. Cygnus got to Rory in the fact that it was one of the first inconveniences in her life.
Objection, Your Honor, again, this is speculation. Simply because it was said in the fact thing, it's not necessarily mean that it's the case.
Rephrase your question.
Have you ever, let's see, you've made comments upon Rory's feelings about his illness, is that correct?
Yes, I have.
And would one of these comments be that you thought that it was an inconvenience to Ms. Greenway?
No, that's not what I said.
Was it, nevertheless, you say that, also in your fact statement, that when Ms. Greenway did not have control of a situation, she would often become desperate?
Yes, I didn't say that.
Your Honor, at this time, we pass.
A couple of questions for you.
All right.
Now, Ms. Dunlop, Aurora would sometimes become desperate. Is that what you said?
Yes, sir.
What did you mean by that?
I mean, in a situation, she could become desperate. Not that she was a desperate person.
Past tense.
Yes, Your Honor. M's illness was a situation that Aurora had trouble dealing with.
Objection, Your Honor, this is outside the scope of my read, direct, we established earlier that.
I find it squarely within the last question, so I'll
Can we repeat the question?
Yes, sir.
M's illness was a situation that Aurora had trouble with, is that correct?
Objection, Your Honor, this is speculation. This is causing her to speculate as to whether or not Aurora could control the situation. She can't do that.
Are you asking the witness to testify on her observations and interaction?
Yes, Your
All
Honor.
right, Ms. Long, based on that, all will.
You need to repeat the question once more.
Yes.
M's illness was a situation that Aurora Greenway had trouble with.
Objection, Your Honor, he has not rephrased the question. He's still stating that he's trying to enter it as fact, not opinion.
Rephrase it. Rephrase it.
Think about this for a moment.
All right.
To Aurora Greenway, from what you have observed, was M's illness a situation, one which as a mother, or otherwise, Aurora Greenway had trouble dealing with?
Any mother has trouble dealing with children's sickness.
Your Honor, at this time, we have no further questions.
Yes, Ms. Dunlop, we're about to step down.
All right, next witness.
At this time, the defense would like to call Redford to stand.
All right. You raise your right hand, please. You do solemnly swear or affirm that the testimony you give this shall be the truth, the whole truth, nothing but the truth, so help you God.
Would you please state your name and age for the jury, sir? Could you tell the jury a bit about your education, Mr. Breedwell?
I first graduated from S.H. High School, and I went to the University of Kentucky and University in Bachelor of Science degree in Aerospace Engineering.
What did you do after college, Mr. Breedwell?
Well, after college, I actually go to college where I joined ROTC. And afterwards, since I attended college in the Navy, and I stayed in the Navy for a few years.
Objection, Your Honor. The witness is launching into a narrative
Well, yeah, it is, but it's background, so I will allow it in the background now to speed things up. So,
Your Honor, could he make it a little bit briefer?
We'll have to let it run its course and see if you think it's running longer than it should. I'll let you object again. But as long as it's background, as long as he's placing himself in context of background, well, it's really their advantage, but I'm going to allow him to do it in the interest of time.
Can I have a ruling, Your Honor?
Pardon?
Can I have a ruling, Your Honor?
Overrule.
Do you need me to repeat the question?
As I said, after I got the lady, I went to NASA. In NASA, I was walking in the research at 12 years.
Are you still a member of NASA?
No, I'm not a member of NASA. As I said, I've already retired.
Are you currently married, Mr. Greenway?
No, I'm not married, but I'm not single by any sort.
Could you explain that comment to the jury, please?
Well, I'm like taken by this oral rule. She's like beautiful, sweet person. She says my heart,
Objection, Your Honor. This line of, this statement is irrelevant.
Relevant?
I believe it was almost unfinished.
All right. The fact he's almost finished doesn't.
I'm just trying to establish his background with the defendant herself so that he may further state his opinions on it.
All right. I'll.
Now, Mr. Breedlove, where did you first meet Mrs. Greenway?
Well, I've been there for years, and then one night when I was coming home from the debate, I looked over and there was that tall, God, that is beauty, staring at me, kind of saluted and stuff.
Objection, Your Honor. Once again, he's going into a very extensive narrative.
All right.
I'll break it down.
All right. We'll break it down and move it on. Thank you.
What happened that night after you first saw Mrs. Greenway?
Like, during the incident, or?
Yes.
As I said, the moment ago, I saluted, so I went away and walked to the house.
Has your relationship developed from this point?
Yes, first we started off with child out, this is the things that we want there. Then we became friends, and we started dating.
And throughout the course of this relationship, have you had ample opportunity to observe Mrs. Greenway and her relationships?
Yes, I do believe I have.
And throughout this time, have you developed an opinion of Mrs. Greenway and her previous relationship with her daughter, Amy Greenway?
Yes, I have felt my own personal opinion.
And according to this opinion, did Mrs. Greenway love her daughter?
Yes, Aurora loved her daughter more than very much.
Now, after Amy was admitted to the hospital, did you see much of Mrs. Greenway?
No, Aurora spent all her time taking care of him. Every moment was good for her.
More specifically, on the last night of Amy's life, were you at the hospital, Mr. Greenway?
Yes, I was, because Aurora had been acting ill and tired and upset all at once.
So, Mr. Breedlove, did you go into the room that night?
Yes, I did.
And Mr. Breedlove, what did you see when you walked into the room that night?
I saw Aurora rushing around trying to look like she's trying to fix something. She kept saying stuff like, no, not this way.
Objection, Your Honor. That's a hearsay response.
I believe it's an admission by a party opponent, yeah.
Testimony of this witness is that he walked in the room and the defendant was making a statement. Is that correct? That's correct. Overruled.
Do you need me to repeat the question?
As I said, Aurora was running around looking like she's trying to fix something. And she kept saying, this is not this way, not now.
Now, Mr. Breedlove, did you ever see Mrs. Greenway pull the plug that night?
Objection, Your Honor. That calls for speculation.
Question was, did you see the defendant?
Yes, Your Honor.
Overruled.
No, I never saw Aurora with her.
Now, during all this commotion, did you do anything to help?
Yes, I quickly called her nurse and I realized what was wrong.
Did the nurses come?
Yes, they did, but sadly it was too late.
Now, Mr. Breedlove, at any point during that night, did you see Mrs. Clark at the hospital?
Objection, Your Honor. I fail to see the relevance of that question.
Your Honor, I'm just going back to her previous testimony today in court where she stated that she was in the hospital, and his testimony will clearly state that she wasn't.
During the time, you can ask what during the time he was there, what he saw the witness. Over.
Could you repeat the question?
At any time that you were there during that night, did you see Mrs. Clark at the hospital?
No, not that I remember. I didn't see Ms. Clark at all.
Mr. Breedlove, were you drunk that night?
Objection, relevance.
I'm just going back to a previous statement in testimony and clarifying for the jury.
This witness's previous statement?
No, a previous statement of Mrs. Clark's.
Your Honor, he was asking if he was drunk, not if Ms. Clark
Right,
was drunk.
I'm not sure that this witness's state is an issue at this point.
Your Honor, may I respond?
Yes.
He here is also as an eyewitness to the events, and I'm just clarifying that he had a clear impression of what happened that night.
Well, the fact of whether or not he was drunk that night is irrelevant.
Well, I suppose you could come from, and go back so far it's in front of itself, so to speak. But the point is that this gentleman's powers of observation has not been assailed at this point, therefore there's no reason to establish that he had powers of observation at that time, so I'm sustaining correct.
Yes, Your Honor.
I have that stricken from the record. Since you sustained.
All right, that was very correct.
Mr. Breedlove, in your opinion, based solely on your observations, did Mrs. Greenway love her daughter?
Yes, and the second thing, she left out of the
That's the witness, Your Honor.
May I proceed, Your Honor? After your first encounter with the defendant, Aurora Greenway, was it not 2 months later until she even spoke to you?
Yes, it was 2 months after.
And since that time, you have been pursuing her since that time for the past 18 months, right?
Well, we were friends first, then I started pursuing.
Objection, Your Honor. Witness is being non-responsive.
All right, to the question.
Yes, I have to go with that.
And on the night that M. Greenway died, you were not at your hotel room, but at the hospital.
That's what I said, it was a yes.
And isn't it true that she seemed more upset than normal?
As I said earlier, she's more upset, more tired.
Objection, Your Honor. He's being non-responsive again.
Your Honor, may I respond? I believe he was answering the question. He asked how she seemed that night. He was stating that she looked upset to him.
The original question was how did the defendant see?
It was a yes or no question.
All right, break your question, I'll sustain it.
She did seem more upset than normal. Is that not correct?
A moment of yes.
And at that night, on June 13th, you went to bed at 11 o'clock.
That's about the time I think I fell asleep in the hospital. Regularly.
And you were awoken again at 3 a.m. Is that not correct?
Yes, I do recall it's about the time for that.
And you went to M. Greenway's room,
Yes, I had some notes in
and you heard a respirator beeping, and you saw the defendant, Aurora Greenway, holding a cord, some cord.
That's right, I saw the world over the pool, some water, and I saw a different machine, like a broken TV.
And okay, you did see her grabbing at and hitting various parts of the equipment that was surrounding M. Greenway.
I understand, yes, I did.
And at this time, we pass the
All
witness.
right, any further?
Go, Your Honor.
Okay, you may step in.
Your Honor, at this time, the defense would like to call defendant Aurora Greenway to the stand.
All right. Ready? Do you solemnly swear or affirm testimony you shall give this matter will be the truth, the whole truth, and nothing but the truth, so help me God? You go ahead.
Please introduce yourself to the jury.
My name is Aurora Greenway, and I live in Kansas City as I have all my life.
How old are you, Mrs. Greenway?
Don't you say I'm older than you, sir?
Are you married?
I was married, but my husband is no longer with us.
Do you have any children?
I did have one daughter, anyway, she passed away not too long ago.
Ms. Greenway, while Em was in the hospital, where were you?
I was there by her side almost day and night, making sure that she had the best care possible.
Did you talk to Em while you were with her in the hospital?
Yes, we talked frequently. We, in fact, we shared more than we had in years.
What was your relationship with Em like while she was in the hospital?
It was very good. We talked about many things, and I just knew that our relationship would be so much better when she got out of the hospital.
So what did you do to help Em's recovery in the hospital?
Well, aside from just being there like any parent would, I made sure that the hospital staff was on time with her medication and that she had the best care possible.
How well did the hospital staff, how quickly did the hospital staff respond to Em's needs?
Well, usually not very quickly at all. Sometimes I would use a call button and they'd say, "Oh, see here soon," but it always turns out.
Objection, Your Honor, it's a hearsay response.
Just going to the state of these witnesses, not as a result.
Would you like me to repeat the question?
Usually if I ever did call them, it would be over an hour before they came to the room.
So what did you do then?
Sometimes I would actually go physically drive them into the room to make sure they came. I would at least, go tell them to come.
And what did you observe about the way the hospital staff reacted to this behavior of yours?
Well,
We object, Your Honor. We fail to see the relevancy of this.
Your Honor, the opposing counsel has already tried to attack the defendant as being controlling, and we're simply trying to ask her, how the people in the hospital reacted to how she was.
Can I respond, Your Honor? We haven't got to question this person at all. I don't see how we are trying to attack.
Well, I think what counsel stated is that through the cross-examination or examination of other witnesses, you suggested controlling nature, so I'm allowed to address that.
Would you like to repeat that? What did you observe about how people in the hospital reacted to your behavior with them?
well, I'm sure they saw me as very demanding.
Were you demanding, Mrs. Greenwood?
Well, of course I was. That was my baby laying in that bed, and I wasn't going to watch him suffer.
You mentioned the nurse's call button. When did you use this call button?
Any time that the nurses weren't there, so a lot.
Did the nurses respond to you using this call button?
Sometimes they did. Usually it was a very long time. In fact, one time I just disconnected the button because it was of no use to me and them.
Did you ever touch any of the other equipment in the hospital room?
Oh no, aside from just using the television and turning on and off lights, the nurses never showed me how to use anything else, so I didn't.
Mrs. Greenwood, was it inconvenient for you to be with your daughter in the hospital?
No, not at all. In fact, it was kind of an honor for me to be there taking care of my daughter.
Now, Mrs. Greenwood, when did you first meet Westbrook?
Well, it was many years ago. He first fell in love with my daughter, him.
So, have you known him for a long time?
Yes, he's been making life quite wistful for me then for some time now.
In your opinion, what kind of man is Flat?
Objection, Your Honor. Calls for unfair characterization of Flatford.
Your Honor, the defendant has already testified that she's known him for 10 years, more than 10 years. We're just asking her to give her impression of him.
The relevance of her impression of him is
To better describe the relationship between him and Flat, which Flat has already described as not great.
I'm sustaining this.
Thank you, Your Honor.
Mrs. Greenway, did you approve of your daughter's marriage to Flat?
No, sir, I didn't, but I never forced him to share my business.
Did Flat and him have any children?
Yes, they had 3 beautiful children that live with me now.
How often does Flat visit his children?
Objection, Your Honor, we fail to say the relevancy of how often Mr. Horton visits his children.
Your Honor, we're simply trying to describe Flat's relationship with his children, which he has already attempted to, which he's already testified about.
Haven't we crossed the street already?
Yes, sir, Mr. Horton.
But your objection at this point is relevant?
Yes, sir.
All right, overruled.
How often does Flat visit his children?
Well, he's only seen his children once since his wife died.
And what happened to Flat after Ann died?
I'm not really sure what's happened to Flat. I've only seen him once since she died, and all I know is he has a large amount of money somewhere.
How do you know this?
Well,
How do you know this?
well, I was with him when he and Ann had a life insurance policy taken out, and now he has $500,000 from that policy somewhere with his name on it.
Did Flat ever visit Ann in the hospital?
He did visit her occasionally.
How did Ann appear to feel during Flat's few visits?
Well, it was quite odd that she stayed quite cheery throughout her entire hospital stay. The only time she appeared to be sad was when Flat visited her.
Ms. Greenway, when did you first realize you were being accused of murdering your daughter?
I was at the country club playing tennis one morning, and the police came and dragged me down to the police station.
Was anyone else at the country club with you?
Objection, Your Honor, we feel this is irrelevant of anybody else being with her at the country club.
Your Honor, we're just attempting to describe the situation around her accusation.
May I respond?
Yeah.
Your Honor, we feel that her actually just going, being arrested is enough for this case, and anybody else with her is just
Counsel, if you can demonstrate the relevance of who was with her in the circumstances of her arrest, I'll allow it. Otherwise, at this point, it seems irrelevant. I'm sustained objection.
would you like me to object again, or are you just going to?
No, I'm just sustained objection.
Thank you, Your Honor.
Ms. Greenway, where were your children when you were taken to the police station?
We object, Your Honor, to the relevancy of where the children were at, is relevant to this case.
I believe that the children were in Aurora's custody, and because she is the only one taking care of them, it's very relevant to how she is taking care of them since she's had custody.
Still fail to see the relevance of this, her actually having the children, according to the night question.
Demonstrate to me, any counsel, what the relevance is of this.
Aurora did have custody, sole custody of the children when she was arrested, and the relevance is that when she was arrested, she attempted to take care of the children and was not allowed to see to it that the children were with someone who could watch over them when she was arrested.
And what does that add or detract from the guilt or innocence of your client?
Your Honor, it shows that the only thing on her mind was her children. When she was accused, she was not.
All right, I'm sustained objection.
Thank you, Your Honor. We ask that the statement be made during his argument be
Stricken from the record. Well, that would have been a bench conference in real trial, but you wouldn't have to start there. All right, move on.
Thank you, Your Honor.
Mrs. Greenway, where were you? Mrs. Greenway, what happened while you were with the police?
The police were trying to get me to confess to this awful crime, and told me that they wouldn't let me go until I did it.
Did you confess?
Oh, they told me that I could not lie under oath, so no, I didn't confess.
When did the police release you?
Well, it was around 9 o'clock at night.
Where did you go when you were released?
I went straight home.
Mrs. Greenway, what exactly happened when you woke up in the early morning hours of June 14th?
Well, I was asleep, and
So what did you do?
I stayed there to see what I could do until some nurses came, and when the nurses came, it was too late.
Did the hospital staff inform you of when Em had died?
Yes, we had one, I was sick, and she died. Still follow her.
Why did this event this morning on 14th seem so sudden to you?
All the doctors have been telling me that Em was going to pull through the coma.
Objection, no, that's hearsay.
Thank
We ask for that to be stricken to the record. Thank you, Your Honor.
Counsel, do you want to argue an exception or any kind of hearsay? Didn't mean to cut you short, you were standing up.
No, sir, I'm going to rephrase the question.
All right.
Thank you, Your Honor.
At that time, what was the general idea in the hospital about whether or not Em was going to recover?
Well, so I believe that Em was going to pull through the coma, and all the grandmothers fathers, and I knew that Em was going to fight that coma and pull through.
So then why did it seem sudden to you that this happened this morning?
All I knew, she was people name in this coma, and all of a sudden she was gone.
Ms. Greenway, did you pull the plug on Joseph Green?
No, I did not.
Your Honor, with my excuse.
Your Honor, may I proceed?
Yes.
Just for the record, would you please state your name to the jury?
My name is Aurora.
I mean your age,
Greenway.
excuse me, I'm sorry.
My name is Aurora Greenway.
And would you please state your age?
So I'm older than you, and so that's all that matters.
No, it's not. Would you please state your age for
You
the
must
record?
know I'm 55 years old.
Thank you. You have been a widow for many years,
Yes, I have.
and Em was your only child, correct?
She was my older daughter.
And over the years, you were the only one to protect and help your daughter?
Well, we had a domestic associate that helped me out, but we were the only ones taking care of him.
And you helped with money problems?
I helped him with anything that she needed.
And you helped with her children?
Yes, whenever she needed me to write her.
And you helped when Em became ill with cancer?
And my limited abilities, yes, I did.
In fact, you made it your job to take care of Em while she was in the hospital?
Parents' job is to take care of their children, so.
And you were with her during day and night, correct?
Yes, I was.
Now, Em's cancer caused her great pain.
She always seemed to be in pain, yes.
And you suffered personally just watching her lay in pain. Okay?
Yes, I did.
When Em slipped into a coma, the doctors put her on life support, correct?
Yes, when she put the phone away.
Now, Ms. Greenway, you knew that this life support system was keeping your daughter alive?
Yes, that's what the life support system does, something like that.
And you knew that if that machine stopped or became unplugged, your daughter would pass away?
That's what the doctors told me, yes.
On the night Em died, you were staying in Em's room, correct?
I was there like I was last night.
And please answer yes or no. During that night, you unplugged a cord around your daughter's bed?
Early that day, I unplugged.
Objection, Your Honor. Ask, witness is being non-responsive. Ask for a yes or no response.
All right, answer the question.
Once again, please answer yes or no. During that night, you unplugged a cord around your daughter's bed. In fact, your friend Rhett saw you holding a cord around 3 a.m.
Do not know what that song.
Based upon what Rhett has came on testimony today from what he said. Is that correct?
Yes.
And Rhett yelled for nurses and doctors to come help him because the respirator was beeping.
I suppose so, nurses came.
When these nurses and doctors arrived, you were alone with him,
Yes, I was.
and the life support system was unplugged.
Well, I did not know at the time if it was unplugged, all I knew was it was breathing.
However, the respirator was not working. The life support system was not working. And your daughter could not be resuscitated, correct?
She was already gone.
Ms. Greenway, you love your daughter enough to do anything to her, correct? For her, correct?
Anything within reason.
It's not we passed it.
Okay.
Yes, sir.
Mrs. Greenway, what were you doing exactly when Andrew passed away?
I was asleep.
No, we have no recourse.
All right.
All right, it's time to finish, Russ.
All right. All right. Ready for closing arguments.
Yes, Joe, we are.
All right.
At this time, I ask that 1 minute of my overall time to say something.
Now, presume that, then we will give you that.
Yes.
Okay.
May I proceed?
Just a minute.
May it please the court, ladies and gentlemen of the jury. Now, as we came to you today with this case, we were confident in the evidence we were going to bring forth. And by having done so, we feel that we have proven to you beyond a reasonable doubt that Aurora Greenway is guilty of committing this murder. Now, in order to sustain our burden of proof in this case and to prove Ms. Greenway's guilt, we had to do 3 things. The first of these 3 things was to establish that the disconnection of the life support system, which was the event that led to the respiratory failure that caused Ms. Greenway's death. Now, this was indisputably proven to you by Dr. Radford, who stated it was evident that someone had intentionally tampered with the life support system by unplugging. He also stated that M could not have survived without that life support system for any reasonable amount of time. Now, the second thing we had to prove to you was that it was M. Greenway herself who disconnected the life support system. Now, there were several things that contributed towards this. First was a statement given by Pat Clark, who told you that she saw Ms. Greenway leaning down by the bedside of M and tampering or messing with the plug. Now, second witness, Brett Butler, also stated that he not only Brett Breedlove also saw the defendant tampering with the cord, not only tampering with the cord, but also holding that cord in her hand. Now, another thing that points towards the guilt of the defendant is that she had ample time to disconnect this cord because she was the only one in the room at the time. Now, this must be true because there is no other solid evidence that states otherwise. The third and final thing we have to prove to you was that the defendant acted knowingly and intentionally in disconnecting said life support system. Now, there were several things that contributed towards this also. It was told to you today through Pat Clark's testimony, through things that she said, that as she was shoved out of the room by Ms. Greenway when she tried to visit him, that Ms. Greenway told her that this was a special night and that him would be fine. Ladies and gentlemen, that night him was not fine and was murdered. Now, the defense in this case has offered you no reasonable doubt. What they have offered cannot be supported under any scrutiny. But what we, the prosecution, have offered to you is undeniable proof, ladies and gentlemen. And that undeniable proof will lead you to the truth. I ask that you return from your deliberations with the ruling that M. Greenway, that Aurora Greenway, is guilty of murdering her daughter. Thank you.
May it please the court. Ladies and gentlemen of the jury, my co-counsel came to you earlier and told you that we were going to show you the truth, the evidence, and the facts about Aurora Greenway and about what happened that night. Ladies and gentlemen, that's exactly what we've done. This case is not about a mother who loved her daughter too much. A mother who couldn't get control of this disease. No, ladies and gentlemen, this case is about a mother who on the night of June 13th touched her daughter to bed for the last time. When she woke up, somebody had taken her daughter. And that same mother is now being wrongly accused of murder that she held no motive to do, her own daughter. Now, the prosecution has tried to lay the burden of proof on the defense. Folks, the defense did not have to come forward today. We didn't have to come up here and build up Aurora Greenway's testimony. Careful. The prosecution has said, well, it's got to be true because they haven't offered anything else. That's not the case, folks. As far as I know, the legal system works that you are innocent until proven guilty. They have to prove to you beyond a reasonable doubt that my client's hand was the one who unpulled that plug. They brought 3 witnesses today to try to do that. Ladies and gentlemen, all those 3 witnesses have done was prove further that my client is innocent. They brought Pat Clark. Well, Pat Clark had been drinking that night. Pat Clark was drunk that night. Pat Clark had been driving that night. We are lucky that Pat Clark was able to even come to this courtroom today to testify. We are lucky that 2 tragedies didn't happen that night. She's testified herself. She does not remember clearly everything that happened that night. That many parts of that night were fuzzy. Ladies and gentlemen, she does not remember clearly what she saw that night. Then they brought Dr. Jordan Ratchford. Dr. Jordan Ratchford couldn't tell us when the respirator was unplugged. Couldn't tell us when M stopped breathing. Couldn't tell us when the alarm was triggered. All Dr. Ratchford could tell us was true, Annie Greenway is dead. Nobody disputes that. Then they brought Flat Horton to the stand. Flat got up here today and he told you that Aurora Greenway is mean, that she's mean to her daughter, that she's controlling. Ladies and gentlemen, that's not necessarily true. Aurora Greenway loves her daughter. Aurora Greenway cared for her daughter, and Aurora Greenway's only ambition in life was to improve the quality of life of her daughter. And we've also brought a few witnesses today to show you that. We brought Rosie Dunlop to the stand. Rosie told you the truth. Aurora Greenway can be controlled. But what good mothers are? What good mothers don't want what's best for their child? Keep them away from people like Pat Clark, who take them off of these law clients. Then we brought Rhett Breedley. And Rhett told you as well, Aurora Greenway is a good mother. Aurora Greenway wanted what was best for her daughter, loved her daughter, wanted to improve her daughter's quality of life. And the defendant took the stand, Aurora. She told you that she did not pull that plug. That when she woke up, when Aurora woke up, M was already dead. There was nothing she could do. But she fought, ladies and gentlemen, for what she believed in. She fought for M's life. She knew, or as far as she could tell, she truly believed that M was going to come out of that coma. And that's what she fought for. Now, we've shown you the facts today. We've shown you evidence, and we've shown you lots of testimony. And we ask you to rely on that testimony, to rely on that evidence, to rely on the facts. And lastly, to rely on your common sense. To show you the truth about Aurora Greenway, to show you that reasonable doubt exists. Ladies and gentlemen, we asked 5 people in court today a common question. Did you see anybody excluded? Well, we didn't ask Aurora Greenway this. We asked everybody. We asked 5 of the witnesses today in court. Did you see anybody, much less Aurora Greenway, pull that plug? We got 5 common answers. Nobody. Ladies and gentlemen, that is reasonable doubt. That is the truth.
Ladies and gentlemen, I'm going to ask you to do somewhat the same thing. I'm going to ask you to use your common sense. Vince had gotten up here just a second ago and asked you and told you that one of the reasonable doubts they offered, or the reasonable doubt they offered, is that no one actually saw Aurora during a full club. Now, use your common sense. It makes sense that a murderer would not want someone to see them committing a crime. Now, another thing is that they testified that 5 witnesses have said this. Now, one of those witnesses, that quote was straight from Rick. And ladies and gentlemen, we came to you today with the truth. That's what we know. Now, we have to consider the fact that this woman loved her daughter a lot. And she couldn't stand her daughter's pain. She couldn't stand it so much. She wanted to improve her quality of life. And she did that by sending her on to the next one. Thank you.
All right. Take about a 5-minute recess.
I'd like to thank y'all for the participation this weekend. Y'all have been great sports and have been very well prepared and have done an excellent job. Both teams should be very proud. I think but before we didn't get to introduce our judges. The presiding judge was Judge Mickey Sheffield. He is a district court judge here in Beaumont, sitting in, you've been in his courtroom several times today, this weekend. Second judge is Ramon Rodriguez. He's with the Jefferson County DA's office. And third judge is Michelle Smith, and she's with the Mahaffey Weber Law Firm here in Beaumont. And I guess they're ready to give y'all your critique.
If we're going to talk about constructive criticism, perhaps we can begin and go in order. We'll hand off in between each other. Opening statements were both good on both sides. All counsel, however, especially if you're not doing the opening statements, please tell us who you are before you start asking questions. Maybe two of you did that, and we have to figure the rest out from introductions later. No notes, detailed recitation, perhaps a little too detailed in the opening statement for the prosecution. I like the fact that the defense overlooked the theme and continues with that theme all the way through. Of course, you went to the other extreme. You had almost nothing about what you thought the evidence would show. Both of you might want to find somewhere in between those two extremes to work with. Michelle.
I thought both of you did a real good job as far as pace and not getting thrown off. Apologize for the mix-up on my decision. I didn't have any negative comments about it. I think that went really well.
Yes.
I thought the openings were very good. One thing I would commend to you is opening statement is, in theory, you're talking to a jury. Obviously, in this context, you're talking to some judges. You're judging you on your technical merit. But when you're doing your opening statement, it's the first opportunity for you to really lay out your story to the jury. Presumably, you've had the board hour where you take the jury. And that's when you build some camaraderie with the jury. That's when you talk in terms of a team. Well, I don't remember which side it was. One of them kept saying, you are going to see this. And I would suggest to you that you talk in terms of we are going to see this. We're all in this together. You know, you're on my team. You're me. Don't worry about what they say. You're with me. We're going to see all this. Use, a lot of times, nervousness obviously creates adrenaline, and adrenaline creates speed, and you talk really fast. And you have to, something that as you progress, once you do go into the profession, you get to public speaking, you'll learn to force yourself to slow down. And use your pace to emphasize your strengths. And also, I would suggest that once you hit the highlight of your opening statement, that if there's one central matter that you want to establish that you think is the penumbra fact or issue, give a little pause after it. Let it sink in on the jury or the judges. Let it pause and use that pause to punctuate what you just said, and without making it seem as though though you're saying, okay, I'm not going to talk right now because I know you're so stupid, you need to think about it. But use a little pause so that you sink into it.
Really good in front of a jury unless it's the defendant and they're flat out lying and you can prove it. You'll never do that with the problems in one of these cases. Everyone on cross was leading well, and you get away with that on cross. Use it. Never fail to use a tactic that you're allowed to use. There were some objections that if you had made the correct objection at the time, the judge might have ruled in your favor versus ruling against you. There was one objection to a response as being narrative. No, that objection was trying to prove a character trait by specific acts of behavior, which is in your rules. You can't do that. If you'd have made the right objection, I believe that was in the cross-examination of the doctor. And also in the cross-examination of the doctor, hey, if the witness is beating you up, get out. Don't stay there and let the witness beat you up anymore. Just don't. You're going to have some witnesses that no matter how you come in, especially on cross, there's no way you're going to be able to get them turned around into your position. Once you've established that they are always going to be against your position, and you've proven that to the jury, get out. Don't stay there and get beat up. I liked diffusing the situation on the intoxication on the director, Ms. Clark. That was well done. Get it out to the jury in front. Yeah, she was drinking, and we get that out. I do that with my witnesses when I have a situation like that as well. You also do the same thing when your witness has a criminal record. Get it out in front. There was one objection that stood out that perhaps should not have been made because it couldn't have hurt you. When the astronaut was testifying, asked if he'd been drinking, what do you expect him to say? No, of course I haven't. But what if he said yes? Then one of their key witnesses has been drinking now, just like your key witness had been drinking. It's not going to hurt you. Let him answer the question. You might get lucky. He might say, yeah, I have been drinking that night. Hello. The direct of the defendant spent too much time on preliminaries. Should have gotten to the meat of the matter. I know you've got limited time to work with. When you've got limited time, it's precious. Get past preliminaries, get to the stuff you've got to get on. That's about it until we start talking flowers.
I just am going to make a few general comments, and I wrote specific down names for this, and we'll get through a little bit later, and then I know y'all can get on with it. Who is the director of the tax department? I thought y'all had an excellent flow. I thought you were, I thought all 6 of you were great witnesses. All of you were terrific. And I like who did the process. I like the way, I like the way y'all combated one another on an alcohol objection. The only thing the only criticism I had was, if I read her agenda for the fact statement correctly, she admitted having an alcohol problem before. Is that right?
Yes,
I would have killed her with that. And that's part of the general thing I'm going to say. When a witness is hurting you, like Aurora, I thought she did an excellent job of asking her questions, not getting all upset when she did just answer her questions with yes or no, asking questions and getting out of there. I think in the intensity of something like this, when you're presented with this much information, you all kind of have an inclination to use every piece of information given to you. And there's nothing more harmful than trying to cross-wit and put everything in your fact statement. Pick out a couple of key points and just hammer those. And never ask, y'all didn't do it all that often, but try not to ask open-ended questions on cross-examination. Because we have witnesses prepared and these are their obviously good. Who crossed off the record? I think there was some sort of objection about predicate. No, you made the objection. Lay the predicate. Ask the questions you get to recommend. You got the information in that you need to prepare to lay the predicate, especially on a business record.
herself whether or not she would agree with what the defendant would agree with.
See, the reason why I ask that is because had he jumped on that, that gives him something to cross-examine her on, not what would otherwise have. See, now she's got a bias to this mercy killing. Even though they're arguing their client didn't do it, she thinks that she did, you know, and she doesn't believe in it. And the other general statement I had was, if y'all got better about it at the end, if a witness hasn't heard you on cross-examination, when the other party's prosecuting your witness, don't go back and redirect them. That's what he did that, and it just ended up, it worked when they went back and recrossed them. I think that's all I have.
Situations and to make a presentation of the case. And so it may be necessary for you to make a lot of objections and take. In the real world, if it's not going to hurt you, there's no reason to make an objection. The ultimate arbiter is going to be the jury. And the jury is going to hold it against you after a while if you keep objecting, keep objecting, keep objecting. So I'm not suggesting to you that you quit making a lot of objections you make. I'm suggesting to you talk to your attorney advisors or your counselors at school to make sure that whichever one of you does advance, that you might want to consider whether that works in your favor or against you when you finally get to the state. Again, the general rule for a practicing attorney is if it's not going to hurt you, don't make the objections, because all it does is disrupts. Now, there's some, I will first say that many attorneys who like to object a lot try and talk the other side's rhythm. But after a while, the jury's going to hold that against you. The jury's going to think of you as an obstructionist and trying to keep something from them. Juries often view objections as a roadblock, an impediment to a fair and full presentation of facts. So, again, I'm not saying that you don't make these objections. I'm suggesting to you to go to your advisor and ask him or her what they think about it, whether it would serve you in the long run. A couple of fact-specific things, and I'll talk some more about techniques. I don't remember who it was. There was a discussion with the doctor. The doctor kept trying to say that the oncologist was the person who could have made a referral or something like that. Remember that it was that doctor who signed the death certificate, right? And so I think you can hoist that doctor on that card that that doctor is the one who signed the death certificate, not the oncologist, not the ER doctor, anybody. That doctor signed it. Therefore, that doctor is the general care physician for that person. And you might, if you're confronted with that conflict, take that route. I really think that somewhere in here, I keep grasping with it. I know the answer is in here. With regard to the defendant. Between the statement of Brett Breedlove in his first statement and the addendum and the defendant's statement with regard to the timing of the disconnection of the call button and the timing of her being seen holding a cord relates to the timing of her discovery of her daughter's distress, I think you'll find that there's some inconsistencies there that can be used to trip up the defendant's story. And so I went to you looking at that closely, if and when you cross that bridge again. One of you did an excellent job, and I'm sorry I don't remember who. It's kind of hard. I'm trying to write down notes, but I'm also being hit with a lot of objections that I've got a rule on. But one of you did an excellent job rescuing a witness. You had a witness who didn't understand the question. And just, I don't remember the point, but if she had gone this way or that way, it may have helped her. And whichever attorney it was recognized it, jumped in immediately, realized that his witness was in trouble, and guided her out of trouble. Don't be afraid to do that. There may be an objection. The other side may object, Your Honor, he's not letting the witness answer the question, or he's leading, or she's leading, and she's not letting the witness answer. But it's more important that you get that witness out of trouble than you have an objection sustained that you're leading or not letting the witness answer the question. So don't hesitate to rescue a witness who's in trouble. The use of sarcasm can be helpful, but it can also backfire on you. question to the doctor about, I think it was a doctor about life support systems being in nursery or out in the parking lot. It was a good try. The doctor wouldn't answer it. And the more you tried to hammer in on that, the more out of proportion it got. I don't fault you one bit for asking the initial question, because it's placed in context, the fact that these things aren't everywhere. But when the doctor would not go with you, you already made your point. The question itself is the point you made. Once you've asked it, it doesn't matter what the doctor says. If you have a jury trial, that seems already planted in the jury. They've heard the proposition that it's ridiculous to expect to find things elsewhere. And they don't care what the doctor's going to say. So don't cling to that if it's not working. Rosie tried to say that the defendant knew there was nothing she could do to decrease M's pain, and there was an objection. And I don't know why, because that's wonderful ammunition for the prosecution. One of the prosecutors objected, and that's wonderful ammunition that Rosie said. Rosie was willing to say that the defendant knew there's absolutely nothing that she could do to alleviate M's pain, which goes to the motive of the defendant, who's a mother, to ease the pain of their dying child by doing something drastic like that. Lastly, a lot of times you have a tendency, you've got a question you want to ask, you know fairly well what the answer is going to be because you've done this 4 or 5 times and you've got the statements, but you don't let the witness finish the answer before you're already asking your next question. So let the witness finish the response before you ask your next question, and listen to what that witness says. Sometimes it may give rise to another question that didn't like on your list of questions to ask. But again, I think everybody did a very good job, and you have every reason to be very proud of yourself. I know you've all worked very hard on it.
Final arguments, summation by the prosecution. Cogent, organized, hit all the high points as you had to do so. You can tell you carefully planned that out and had that ready to go. And a theme that I often do in doing rebuttal, hit the common sense, especially if the defense has come back with what I will tend to, when I'm doing that argument, always characterized as an outlandish defense. Then you ask the jury to take a reality check and you bring them back to her. And that's the way a prosecutor should make his or her argument. Summation by the defendant also does something that I like to do. Continue the theme from the beginning, from the opening. You open with the theme, you close with the theme. Continuity, closing the circle. Very good. Some things to consider. If you've got a question that can't be answered by the other side, ask the question in your summation. They'll never be able to answer it, and you end up coming ahead on that point. Ended up very well. I would impress upon you, sir, because it's a problem I have too, hand gestures and techniques. Some of them were almost stilted, especially the, okay, you're not doing it, all right? Just simple, slow gestures of the hand. You use the prayerful technique that some people like to call it. I use that too. I've been doing this for 15 years. I know them all right? Everything was wonderful in final art.
I thought that your rebuttal was very good. I don't know if it was scripted or not. It didn't appear scripted, and I thought that was really good to be able to come up with that. Did you tell me the witnesses, did you tell me what a witness said and then said it was scripted?
Yeah, you did. There is one point.
I'm sorry, if and I thought you were very, very relaxed and very easy to listen to. And the only little criticism I have is I think you said that 6 witnesses would end the same way, and then you didn't want to inform the jury that it's argument and going back to correct the files and
I don't really have much more that I would add to that other than to restate what I suggested to you for your opening statement. Use silence as your ally. Make your point. then let silence punctuate. You've got your point, you got to make that silence punctuate, and use your tempo to really highlight the point. But again, I thought everybody did a very good job.
We're ready to announce.
Before you announce it, I would like to say this. I've been doing this for 3 or 4 years now, and on my ballot, this is as close as heat as I've ever had. And it's a shame that there has to be someone advancing and someone not, but both sides did an excellent job. Does it mind you? Oh. Ask him, have you reached the verdict? Members of the jury, have you reached the verdict?
Your Honor, we have.
All right, what is that verdict?
With the jury find the defendant not guilty.
Westbrook, I have a check for y'all, $1,500, paid by the Jefferson County Young Lawyers Association, and best of luck at the state meet. Trophy's yours, and good luck. Bye.